Ready? Exercise number 29, legal matter. Start. When the legality of the power of central government to detain people during an emergency proclaimed under the Constitution was heard, the doctrine of basic structure had already taken shape. Ironically, only Justice Beg refers to the basic structure, principles in the habeas corpus case and dismisses the same as a principle of interpretation rather than checks and balances to government action. The Supreme Court emphatically overruled the habeas corpus narrow interpretation of life and personal liberty. Anti-terrorism laws have been tested against a stagnant standard of right to life before the Supreme Court came up with the golden triangle of fundamental rights. The court upheld declaration of a group as a terrorist organization even without giving the group an opportunity of being heard. Even though Article 19 under bracket 1 under bracket C recognizes a fundamental right to form groups and association. However, the most absurd principle upheld by the Supreme Court in the context of terrorism and money laundering laws under bracket PMLA bracket out is that bail would be granted only if the court is satisfied that there are grounds for believing that he is not guilty of committing such offense. On the pretext of terrorism, exceptions control the rule. Stop. Next para. In NIA versus Zahoor Ahmad Shah Watali under bracket 2019 bracket out, we get a glimpse of unlawful activities under bracket prevention bracket out act under bracket UAPA bracket out and the right of bail. The illusory right is painfully obvious from the court's acknowledgement that the burden to be discharged by the accused is abduous. The accused would have to satisfy the test of innocence based on allegations in the FIR and material collected. Even though the accused under law does not have access to all the documents, investigation agencies are not bound under law to share material collected during investigation. Stop. Next para. The energious dichotomy between the grandiose language used by the court to describe personal liberty and reality is brought out in strong dissent in the arrest of Sudha Bharadwaj and others under bracket even though none of them were mentioned in FIR number 4/2018 dated 8/1/2018 bracket out. In Romila Thapar versus others versus Union of India under bracket 2018 bracket out. But lofty edicts in judicial pronouncements can have no meaning to a citizen unless the constitutional quest for human liberty translates into securing justice for individuals whose freedom is under threat in specific cases. This incongruity is underscored in Chief Justice of India's opening remarks at the First International Judicial Conference 2020 in February 2020 that individual rights were at the heart of the Constitution. This was at a time people protesting against the Citizenship Amendment Act were arrested under UAPA. Stop. Next para. The patent lack of respect for human life and dignity is painfully clear from the 2016 ruling on the dreaded Armed Forces Special Powers Act. In extrajudicial execution, Victim Families Association versus Union of India under bracket 2016 bracket out, the Supreme Court fully noted that out of 1528 fake encounter cases, details were available only in 62 cases, and FIR was not registered even in one case. The NHRC had concluded that in 31 out of 62 cases, the encounter was not genuine. Stop. Next para. The conspicuous gap in checks and balances is highlighted in case where after 24 years Nambi Narayanan was awarded compensation for malicious arrest and harassment. The state of Kerala was reluctant to investigate this egregious violation of basic human rights. Stop. Thank you very much.